alaikum. May I start by adding my own thanks to Dr. Hamid Mirah and to his excellent team at the SCCA for putting on such a terrific inaugural conference for the SCCA. The only downside being that the standard has been set extremely high for next year's event, but I'm sure they will match it. As Tom previewed, I'm going to talk about the arbitration of disputes under joint operating agreements, or JOAs, in the oil and gas industry. I'm going to start by considering the nature of the parties' rights and their duties under the JOA. I'm then going to examine a specific type of dispute which arises where those rights and duties conflict. And finally, I'll examine why it is that in practice arbitration is so very well suited to resolve disputes of this sort. But let's start with the terminology and with the contractual structure. So by a JOA, I mean the joint operating agreement which governs the relationship between joint venturers in relation to the exploration, development and production of an oil and gas asset. Together, those joint venturers will hold the hydrocarbon asset under the terms of a PSA, باللغة العربية اتفاقية مشتركة الإنتاج, or perhaps a different form of contract or license with the host state. And although the nomenclature can change between jurisdictions, in Iraq we talk of a technical services contract, a TSC, not a PSA, but the structure is broadly the same. Now, one of the participants will generally need to lead the joint operations, and that role will be performed by the operator. In my diagram up on the screen, that's IOC1. So the operator is commonly, but not always, the party with the largest interest in the project, because the position requires sufficient technical and financial resource to conduct the joint operations. And as the other venturers, as the national oil company, you want the operator to hold a significant interest in the success of the joint venture. And it's up to the operator to liaise with the government on behalf of the contractor group and to manage the relationship under the PSA. So the JOA is the contract which governs the appointment, the functions, the responsibilities, and ultimately, if necessary, the removal of the operator. But it will also detail the relationship and the level of control between the operator and the non-operators, as well as the consequences if any of the venturers, including the operator, breach the JOA terms. But overarching all of that complexity, the overall concept is simple: to facilitate joint operations to develop the hydrocarbon asset and produce profit for all, while spreading the costs across all of the venturers. So, having set the scene, let's now consider some of the most important rights of the parties under the JOA. And the first, Article 9 under the 2012 AIPN model JOA, is a very important one. It's the right to own and dispose of your share of the oil and gas production. And that's, of course, what it's all about. I've also put up the key right of the operator, Article 4.2a in the AIPN form. But the upside of taking on all of this responsibility is that the operator is an exclusive charge of joint operations to explore, develop, and produce the hydrocarbons. But that isn't an unfettered right, of course. It's not completely free hand. It's subject to checks and balances under the JOA, and in particular, some important matters upon which the parties must vote. Now, a very common area for dispute under the JOA is the standard of care exercised by the operator in performing its duties. And on this slide, I've drawn out three of the most important duties and hence source of disputes from the most popular model forms. Most JOAs will generally include some wording along the lines that the operator will act in a diligent, safe, and efficient manner in accordance with good and prudent petroleum industry practices, or words to that effect. And that's Article 4.2.B.2 of the 2012 AIPN model. The operator is also in charge of the finances for the venture, and management of the joint account is a key responsibility. So you must exercise due care with respect to the receipt, payment, and accounting of funds. But few parties would accept the role of operator, and it's a very onerous and responsible role, if they had no protection from the huge potential financial exposure that might arise if something goes wrong during joint operations. So as a result, a fundamental principle that stands at the core of most JOAs is that the operator shall neither gain a profit nor suffer a loss as a result of being the operator. Now, that principle aligns the operator's interests with those of the non-operators, and it aims to ensure that the operator will only succeed if the joint venture as a whole is successful for the benefit of all, and its return is to enjoy its proportion of the proceeds in proportion with its participating interest, just the same as the non-operators, no additional remuneration. So that is a very fundamental principle, but equally, as you see, it's a very broadly, you might say loosely, defined one, and that lack of specificity can lead to disputes, and that's what I'm going to look at next. Now, it's vitally important to the success of the joint venture that it's sufficiently funded at every stage. And that's typically achieved through the cash call system, by which the operator issues a cash call to the joint venturers, including itself, for future estimated expenditure. So in simple terms, each joint venture must contribute its share to the anticipated expenditure in proportion to its participating interest. The operator, as we've seen, must operate a joint account to track that money in and the resulting expenditure on budget items. Now, the JOA will typically provide for cash calls denominated in US dollars. The operator will enter into a range of necessary contracts, rig hire, construction contracts, as Victor has addressed, ancillary service contracts, a whole range of complexity, and it will commit the joint venture to significant expenditure. And that all needs to be paid out of the joint account from the benefit of the cash calls. Some will be paid in US dollars, but of course, some must also be paid in local currency. And many a dispute under JOAs starts with the refusal of a joint venturer to pay its cash calls. And what we've seen in recent years in particular are that exchange currency control issues have prompted JOA disputes, particularly in jurisdictions where the macroeconomic picture has led to a devaluation of the local currency, and that's disturbed the economic balance of the project. So here's the problem which I would like you to think about. What happens if foreign currency controls are introduced? The joint venturers earn local currency from selling production to the state, but then they're legally prevented from changing their local currency to dollars. So they are in effect stranded with devalued local currency, and they can't necessarily do anything with it. At the same time, they're receiving cash calls which are denominated solely in US dollars. So they've got local currency coming in, which they can't do very much with, and which is losing its value, and they're paying out US dollars all of the time. That's not a happy position in which to be. So in that scenario, The only venture which can actually use that pile of local currency and keep its own dollars in the bank instead is the operator. Because as the operator, it can spend local currency on the joint venture contracts which are payable in that local currency. And the dispute that arises under the JOA in that scenario is this: is the operator earning an illegitimate profit by virtue of its role? On one view, is the operator abusing its privileged position and breaching the duty not to profit that we've just seen on the previous screen? So, what issues arise, and is this really a problem? Let's consider how this might play out in an arbitration, whilst keeping in mind, of course, that whilst we have looked at the model forms, the governing law of the JOA will overlay that and will play a very important role as to how those rights and duties are interpreted and applied. But in relation to the cash call, can the non-operator insist upon paying in local currency instead? Well, probably not. The JOA will very likely give the operator a discretion to accept cash calls in other currencies, but it won't be obliged to do so. And I've seen the operator politely refuse those requests for flexibility and insist that the cash calls must continue to be paid in US dollars. Well, how about compliance with local law? Has the operator done anything wrong? Well, probably not, because the operator will say it is following local law to the letter, which is exactly what a diligent operator is obliged to do under the JOA. Has the operator breached the JOA? Well, it's easy for the non-operators to complain in the abstract and to say that this must be in breach of the JOA. But which particular term of the JOA, express or implied by the governing law, can they point to? There's probably nothing more on point than the general principle around neither gaining a profit nor suffering a loss by acting as an operator. Well, if that doesn't work, how about a restitutionary claim to get money out of the operator using a form of unjust enrichment, which is available under many governing laws? Is there a form of fiduciary relationship where the operator holds everything on trust for the other co-venturers? Well, that's a very complex area for analysis, and different governing laws approach it differently. But many would say, no, the operator is not acting in a purely fiduciary role. Even if there has been a benefit to the operator, can the non-operator really say that it is lost out as a result? Well, maybe it's difficult to say that, because isn't their position a consequence of the terms of the JOA applied in the circumstances of a change in local law, and nothing more than that? Well, even if they haven't actually lost out, does that mean that they have no claim? Because can the non-operators say that they're entitled to an account of any profit made by the operator as a result of its privileged position? Effectively, they may have suffered no loss, but can they share in any profit which the operator has made through its role? Well, these are all legal theories and arguments for an arbitration, and I have my own views on how such a case would be decided, but I'd be very welcome in other perspectives from the audience afterwards, and of course from the panel. But one of the privileges of giving a presentation like this is that you get to raise all sorts of, hopefully, interesting questions without having to give a definitive answer to any of them. عندي الفرصة بدون المسؤولية يعني. So let's move on to some more certain grounds to finish off with. Why is it that arbitration is so well suited and so frequently selected to arbitrate such disputes? Well, the advantages of commercial arbitration as a process relative to domestic litigation apply, just as much as they do to the resolution of disputes arising in other sectors and contexts. But it's true to say that the benefit of resolution in a neutral forum is prized even more highly in the upstream context, especially so in the case of contracts entered into by private parties with host states or national oil companies, where the alternative is to appear before the courts of the state, or where issues of local law and policy, such as currency control, may be an issue. But it's equally true when you're talking about joint venture parties who may be reluctant to appear in the other's home courts. There's the expertise of the tribunal, and as we heard from our respected panelists yesterday, the ability to select the tribunal is very important, especially in a legally and technically challenging area like this. You may even be able to appoint an arbitrator who's helped to draft the language of the model form JOA, such as our good friend and colleague Tim Martin here. And of course, the advantage of confidentiality is especially important in this industry, given what's at stake. But against that, let me finish on a contrary note about this perceived benefit. Because the very fact that so many decisions on upstream disputes, and JOA disputes in particular, are rendered in confidential proceedings is also a cause of frustration to a lot of people in the industry. And there can be no doubt that upstream practitioners and commercial parties would also benefit from having access to a greater body of published, reasoned awards on some of the upstream disputes and model form clauses most often encountered in practice. But my personal view is that although that's a consequence, we must also recognize and prioritize indeed the desire of the parties in general to maintain confidentiality, and we must respect that. It's their process, they are paying for it, and the principle of party autonomy must always be given great weight in order for arbitration to prosper. So I'll finish there. وأشكركم لحسن استماعكم. شكرا.